Welcome back to Mastering MHA, MBA, and to Chapter 6, Part 4. We have finished the political half of this chapter. Now, the legal half. Here is the thing that catches managers out. The same signed contract does not mean the same thing in Paris as it does in Chicago. To understand why, you need the four legal systems. Start with what a legal system does. Legal systems provide a framework of rules and norms of conduct that mandate, limit, or permit relationships among people and organizations, and provide punishments for those who violate them. They also empower citizens to enter into contracts and to seek remedies when contracts are broken. And they are never finished. Legal systems are dynamic. They evolve over time to reflect each nation's changing social values and its shifting social, political, economic, and technological environment. Political systems shape legal systems. Democracies tend to encourage market forces and free trade. In countries with well-developed legal systems, such as Australia, Canada, Japan, the United States, and most of Europe, laws are widely known and understood. In those countries, laws are effective and legitimate for three reasons. They are applied to all citizens equally. They are issued through formal procedures by recognized government authorities. And they are enforced systematically and fairly by police forces and formally organized judicial bodies. That gives us one of the most important concepts in this chapter. The rule of law refers to a legal system in which rules are clear, publicly disclosed, fairly enforced, and widely respected by individuals, organizations, and the government itself. International business flourishes in societies where the rule of law prevails. Note the last part of that definition. The government is bound to. In the United States, the Securities and Exchange Act encourages confidence in business transactions by requiring public companies to disclose their financial indicators to investors frequently. The rule of law can erode. It is weakened by declining respect for the law, by weak government authority, or by burdensome restrictions that try to forbid behavior already widespread in the society. Where the rule of law is absent, firms face great uncertainty and economic activity is impeded. Nations are primarily governed by one of four basic legal systems: common law, civil law, religious law, or mixed systems. Let us take them one at a time, because the differences have real commercial consequences. First, common law. It is found in Australia, Canada, Ireland, New Zealand, the United Kingdom, and the United States. It is based on tradition, precedent, custom, and usage. Courts interpret the law through statutes, legislation, and past rulings. In common law countries, the national legislature, Parliament in Britain or Congress in the United States, holds ultimate power to pass or amend laws. But because the United States Constitution is difficult to amend, the Supreme Court and even lower courts have considerable flexibility to interpret the law. That is the defining feature. Common law is more flexible than other systems because it is more open to interpretation by courts. Judges have substantial power to interpret laws based on the unique circumstances of individual cases. Second, civil law, also known as code law. It is found in France, Germany, Italy, Japan, Turkey, and across Latin America. Its origins go back to Roman law and the Napoleonic Code. Civil law is based on an all-inclusive system of laws that have been codified. The laws are clearly written and accessible and divided into three codes: commercial, civil, and criminal. Civil law is considered complete because catch-all provisions within the code are meant to cover situations the drafters did not foresee. Here is the key difference, and it is worth memorizing. Common law is primarily judicial in origin, based on court decisions. Civil law is primarily legislative in origin, based on laws passed by national and local legislatures. That difference changes how you do business. On intellectual property, civil law determines ownership by registration, common law by prior use. On enforcing agreements, civil law requires that commercial agreements be properly notarized or registered, while under common law, proof of agreement is sufficient. It changes your paperwork too. Under civil law, contracts tend to be brief because the civil code already covers many potential problems. Under common law, contracts tend to be very detailed, with every contingency spelled out, and they are usually more costly to draft. and it changes what counts as an excuse. Under civil law, noncompliance is extended to include unforeseeable human acts such as labor strikes and riots. Under common law, acts of God, floods, lightning, hurricanes, are the only justifiable excuses for failing to meet a contract. Third, religious law. This system is strongly influenced by religious beliefs, ethical codes, and moral values viewed as mandated by a supreme being. The most important religious legal systems are based on Hindu, Jewish, and Islamic law. Among these, the most widespread is Islamic law, found mainly in the Middle East and North Africa, though countries with very large Muslim populations also include Indonesia, Pakistan, India, and Nigeria. Islamic law, known as the Sharia, is based on the Quran and the teachings of the Prophet Muhammad. Adherents generally do not differentiate between religious and secular life. Islamic law governs relationships among people, between people and the state, and between people and a supreme being. It sets norms for politics, economics, banking, contracts, and many other social matters. Because it is seen as divinely ordained, it is relatively static and evolves very little over time. Most Muslim majority countries currently maintain a dual system, in which religious and secular courts coexist. Indonesia, Bangladesh, and Pakistan have secular constitutions and laws, and Turkey has a strongly secular constitution. Saudi Arabia and Iran are unusual in that religious courts hold authority over all aspects of jurisprudence. This has produced a whole branch of global finance. Strict interpretation of Islamic law prohibits giving and receiving interest. So institutions use Islamic finance, charging administrative fees, or taking equity positions in the projects they finance instead of charging interest. Many issue sukuks, which are Sharia-compliant bonds paying revenue from an asset such as a rental property. Fourth, mixed systems, consisting of two or more legal systems operating together. The contrast between civil and common law has blurred as countries combine them. South Africa and the Philippines mix civil and common law. Indonesia and most Middle Eastern countries share elements of civil law and Islamic law. One system has largely vanished. Socialist law, once found in the Soviet Union, China, and a few African states, was based on civil law with socialist principles emphasizing state ownership of property, with the rights of the state dominating those of the individual. When the Soviet Union collapsed and China moved toward capitalism, socialist law gave way to civil law. Here is the current scale of the Islamic finance point. Our chapter notes put the global market for Sharia-compliant instruments above $2 trillion. It has since grown far beyond that. Global Islamic finance assets reached $5.2 trillion in 2025, growing about 15% year on year, and are on track to cross 6 trillion by the end of 2026. The sukuk market alone now exceeds $1 trillion. Let us recap part 4. Legal systems set the rules and evolve constantly. The rule of law means rules are clear, disclosed, fairly enforced, and binding on government too. There are 4 systems: common law, judicial, and flexible; civil law, legislative, and codified; religious law, most widely Islamic law; and mixed systems, which is what most of the world actually runs. This builds on our chapter notes from Cavoskill, Knight, and Riesenberger's International Business, The New Realities, on legal systems in national environments, updated with 2026 figures on the size of global Islamic finance. We know the systems. In part 5, we look at who actually writes and bends the rules. The 5 kinds of participants in political and legal systems, from governments to the lobby group you did not know was working against you. If this is helping, subscribe, and we will see you there.